Welcome everyone to our webinar on Marketing Mastery, promoting your business safely and effectively. My name is Kathryn Wallace and my co-host is Tayler Berridge-Smith. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email. Please submit your questions in the Q&A box and we'll answer them at the end. And please complete the feedback survey after the webinar. By viewing this webinar, you are eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. To claim, please leave your contact details in the survey that appears when the webinar ends, or contact us via our website. You'll now see a poll question pop up, which we'll leave open for a couple of minutes, and we'd be grateful if you could please answer. Thank you for that. So today we will be discussing misleading and deceptive conduct in advertising, influencer advertising, unauthorized use of content or celebrity endorsements, and sales promotions and giveaways. We'll then finish with a short question and answer session. And now I will speak about misleading and deceptive conduct in advertising. Sorry, but before that, we'll just go to the results of the poll question. So the majority of people said not sure, here to learn. That's great. Hopefully we can help you learn some things about advertising along the way, and please feel free to ask any questions. Okay, so misleading and deceptive conduct in advertising. In New Zealand, the Fair Trading Act 1986 prohibits misleading and deceptive conduct in trade in relation to goods and in relation to services. In addition to these general provisions, the Fair Trading Act also prohibits the making of false or misleading representations in connection with the supply or promotion of goods and services, such as that goods are of a particular kind, a particular quality, or have sponsorship or endorsement. It also prohibits the making of unsubstantiated representations in relation to goods or services or their supply. The prohibitions in the Fair Trading Act apply to the advertising of goods and services. Consumers must not be misled about what they are buying, and businesses must describe their goods and services accurately. You cannot make false claims about your products. What is meant by misled or deceived? This means actions or statements that would lead a reasonable person to form an incorrect belief about the goods or services. In addition, claims made about products must be able to be substantiated. This means you must be able to point to reasonable grounds for a claim that you have made. Reasonable grounds can be information from reputable suppliers or manufacturers, or reliable scientific journals, for example. Essentially, you must be able to point to a credible source to support a claim you are making about your goods or services. The Commerce Commission is the regulatory authority responsible for investigating breaches of the Fair Trading Act, and they have the ability to take a number of enforcement actions, from sending warning or compliance letters, issuing infringement notices for $1,000, to taking court proceedings. Penalties for breaching the Fair Trading Act are up to $200,000 for an individual and $600,000 for a business per offence. By way of a case study, in April 2025, 2 Degrees was fined $325,000 by the Auckland District Court after admitting it made misleading claims in a 2020 to 2023 advertising campaign that its Aussie business roaming was free or at no extra cost, when in fact customers were charged for roaming after 90 days of roaming having been used per year. In many instances, 2 Degrees did not include the 90-day qualifier, and when they did, the court determined that it was not clear enough to correct the impression created by the headline that Aussie roaming was free. Tayler will now speak about influencer advertising.
Thank you, Kathryn. So moving on now to more specifically advertising using influencers and celebrity endorsement. The key aspect with influencer advertising is transparency. Influencers must clearly disclose any commercial relationship they have with your brand or business. This includes paid partnerships, where you've gifted products or services, or where you've provided any other form of compensation. This means that any commercial relationship with an influencer needs to be clearly distinguishable as an advertisement with paid promotion. The New Zealand Advertising Standards Authority, through their Advertising Standards Code, has made it clear that this can be done by using clear labels like #ad or paid partnership. Any omission of information to blur the distinction between an ad or organic content can create risk, such as vague attempts at disclosure, like using incomplete or shortened hashtags like SP, meaning sponsored. It's also important to note that simply tagging a brand or product is not sufficient. Ultimately, an influencer's relationship with a brand must be clear, obvious to the audience, and expressed in a way that is easily understood. The Advertising Standards Authority have indicated that disclosure should be upfront, prominent, easy to be understood by consumers, appropriate for the channel and devices that they use. So, for example, taking into consideration the social media platforms that the content will be shared on, and attached to every piece of ad content. Now, looking to a recent case study from Australia, which has similar regulations to New Zealand, with the beauty brand La Mer. In 2022, a complaint was made to Australia's ad standards regarding what ended up being considered an advertisement between La Mer and an Instagram story by a social media influencer. In the story, the influencer showed a photo of a La Mer product along with the text, "Thank you at La Mer family," and a heart emoji. In their response to the complaint, La Mer stated that there was no paid partnership with the influencer, and the influencer had simply been gifted the product without an obligation to post content. The Ad Standards panel found that while there was no direct request to post content, La Mer chose to send the product to the influencer, knowing that she has a large social media presence and is likely to post about the gift. For this reason, the Instagram story was deemed to be an advertisement rather than an organic post. Regarding the text of the advertisement in this case, the panel found that stating "thank you" was not the same as declaring that the product had been gifted, and as a result, the advertisement was not clearly distinguishable to the audience and was in breach of the code. So cases like La Mer should not deter you from using social media to promote your brand or your business. Business owners should utilize all the resources they have to build their brand name and promote their products. And of course, social media platforms are often the most accessible, affordable, and effective way of doing that. And using influencers can be a very helpful tool. Although using disclosures like paid advertisement across a post can seem like a bit of a detractor, a simple and clearly visible hashtag like #sponsored or #ad, depending on the content, can save you from garnering the Advertising Standards Authority's attention and breaking the Advertising Standards Code. This does not mean that you can bury the hashtag in the middle of a long post, but so long as it is identifiable and clear to a consumer, it should satisfy those disclosure requirements. In addition to making it clear when posts are sponsored, you need to be mindful of what you require your influencers to say in any content. Influencers shouldn't be given a script that sets out their testimonial or their experience. And influencers, although they can speak on fact, such as the ingredients in your product, the place of manufacture, or about where a product is stocked, requiring them to follow a script on their experience with the product limits accuracy and truthfulness and has a high likelihood of being misleading, which, as Kathryn flagged, is a breach of the Fair Trading Act. I'll now pass over to Kathryn to talk about use of content or celebrity endorsements.
Thanks, Tayler. Now moving on to content usage in posts. This intersects with the fair trading obligations to avoid deceptive and misleading advertising. but it also considers the intellectual property of those who own the content you are integrating into a post. When using additional content in posts such as celebrity images, music, and screen recordings, you need to ensure you have the appropriate licenses and approvals in place to actually use that content. Where you don't know if you have the right license or approval, commercial libraries are your friend. Both TikTok and Instagram have commercial music libraries allowing you access to royalty-free music. But where you are using licensed content in a post, make sure you are tagging and attributing the appropriate individual. These restrictions also apply to the use of celebrity names and images. Celebrities can use the Fair Trading Act or their intellectual property rights to protect their image and stop unauthorized use. If you are using a celebrity image to create the impression of an endorsement or a collaboration that doesn't actually exist, then this creates the risk of deceptive and misleading conduct and therefore a breach of the Fair Trading Act. So, what to do when mentioning celebrities? Do not make it look like a celebrity or influencer is connected to a product if they're not. This means you can't say that some prominent celebrity loves your product if they haven't agreed that you can say this. Make sure you have the appropriate rights in place to use any recorded performances or content. Get approval from influencers or celebrities before referencing them in content. And for any lookalikes or impersonators, make it clear that they are just that, not the actual individual. Turning now to a case study. So this is Topshop and Rihanna in the UK in 2012, and this had very similar principles. This was where Rihanna prevented Topshop selling t-shirts displaying her picture. The picture of her was taken by an independent photographer who is the owner of the copyright in the photograph, licensed the use of the image to Topshop. However, Rihanna took action against Topshop, alleging that the use of her image for fashion clothing was not licensed, and that the people buying the t-shirt would think she had endorsed it. And ultimately she was successful, causing the sales of the t-shirt to halt. This reinforces that celebrities can control their public image and how other brands or individuals use or make reference to it. Tayler will now go through some specific advertising regulations for particular industries.
Thank you, Kathryn. So, in addition to the general obligations when engaging with influencers in advertising, certain regulated industries in New Zealand have additional responsibilities due to the nature of their product or services. These include therapeutic products, cosmetics, and financial services. Let's explore at a high level the key additional regulations for each. In New Zealand, therapeutic products include medicines, medical devices, natural health products, and pharmaceutical ingredients. These are regulated by the Medicines Act 1981 and the Medicines Database of Medical Devices Regulations 2003. It's important to note that claims about therapeutic products must be substantiated and not misleading. So as Kathryn flagged before, any evidence that you have to substantiate a claim must be from a reliable source, and you must have that evidence at the time that you made that claim. Advertisements should not create unrealistic expectations about the performance or results of these products, and an advertisement of therapeutic products must also not include testimonials. In terms of financial services, the financial services sector in New Zealand is heavily regulated, primarily by the Financial Markets Conduct Act 2013 and the Financial Markets Authority. Key points to be aware of is that financial service providers must be registered and in many cases licensed. Cold calling for financial products is restricted under the Financial Markets Conduct Act. Financial advice must be appropriate for the client and consistent with disclosure documents. And advertising of financial products must not be misleading or deceptive. Cosmetics are another category in New Zealand that are regulated, and these are regulated by the Cosmetic Products Group Standard 2020. Advertisers should ensure that claims about cosmetic products are substantiated and not misleading, and that products comply with labeling and ingredient requirements, which for most cosmetic products requires ingredients be listed in descending order of concentration. There are also additional packaging and labeling requirements depending on the nature of your product. In conclusion, influencers can still be engaged to promote regulated products in New Zealand, but businesses must be aware of and comply with industry-specific regulations. It's crucial to understand the specific regulations that apply to your industry. Ensure that all advertising content, including any influencer posts, comply with these regulations. You should also always provide clear guidelines to influencers about what can and cannot be said about your products or services. And it's also important to review all influencer content before publication to ensure compliance. Kathryn will now discuss sales promotions and giveaways.
Thank you, Tayler. So sales promotions and giveaways. The key difference between them is that a sales promotion is tied to a consumer's purchase of a product, whereas a giveaway does not require a consumer to spend any money to enter. Sales promotions are caught by the Gambling Act 2003, and there are strict requirements which apply to them which must be adhered to ensure they are not a type of gambling which requires a business to hold a gambling license. A sales promotion must meet the following criteria. Participation requires a person to purchase the goods or services promoted for a price not exceeding the usual retail price. The date or period on or over which the outcome of the gambling will be determined is clear to the participant at the time and place of sale. The person is not required to pay direct or indirect consideration to enter other than to purchase the goods or services promoted. There is a limited exception where the standard rate for postage or, for example, text is okay for an entry. And the outcome is determined randomly or wholly by chance, or partly by chance and partly by the application of some knowledge or skill. Key to a sales promotion is that they must be for the purpose of promoting the sale of your business's goods or services at their usual retail price and must be complementary to your business. They cannot be your business itself. For example, you operate a beauty product business and you run a sales promotion where if a customer buys a particular product at its usual price, they then go in the draw to win a hair straightener. This differs from Australia, where with a permit, businesses can essentially run back-to-back prize draws as their main business offering. It is very important to be clear that this is not the case in New Zealand. Gambling is heavily regulated by the Department of Internal Affairs, so it is important to comply with the Gambling Act when running a sales promotion. However, when done correctly, both sales promotions and giveaways can be effective marketing tools. For both sales promotions and giveaways, detailed terms and conditions are crucial. It must be clear to participants how to enter and the conditions of entry, how the winner will be determined and notified, the dates on which the sales promotion will run for, what the prize includes. Note that some prizes are prohibited. These are things such as alcohol, firearms, restricted weapons, and tobacco products. To avoid misleading and deceptive conduct with sales promotions and giveaways, businesses must ensure that all marketing materials align with the terms and conditions, provide clear and accurate information, and include the critical information required.
Great. So that concludes the main part of our webinar. You'll see on the screen we've provided a free download link for our marketing plan template for a digital business, and you might find that publication useful. You might also be interested in our upcoming event, which is planning your exit, tax, and legal essentials for startups. So feel free to register now to join that one. So we will answer some questions shortly. While those are being submitted, I'll just take a moment to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of 150 plus specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registrations, plus much more. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, we also offer a dedicated desk extension service to manage your high volume business as usual legal tasks. To learn more about how our membership or desk extension can help you, feel free to request a free consultation when the survey appends at the end of this webinar.
Thanks,
And
Tayler. We'll answer some of your questions. So I've got one here which says, do I need to be mindful of brands I wear when marketing my business? For example, if I wear a top that says Nike, do I need permission from Nike? And what are the rules around seeing other brands? So as we've mentioned in the presentation, you would need to be very careful not to give the impression that your business is associated with or endorsed by Nike in this instance. So the best approach when you are producing content is to not have any third-party branded products in your marketing unless you have actually agreed that they will endorse or sponsor your product and you include the appropriate hashtags and ads that Tayler has mentioned.
great. I've got another question here. First off, I wanted to say thank you, Colin, for your lovely feedback. Much appreciated. I'm glad this was helpful. And we've got another question. If a negative review is posted online and you suspect it is from a competitor, is there anything you can do about it? So from a kind of wider perspective, for negative reviews in general, you cannot delete reviews unless they are abusive or otherwise offensive. Under the Consumer Guarantees Act, you have a duty to investigate every customer complaint as they arise. So you cannot delay it or needlessly refuse to investigate, even when you think the complaint is not justified or is from a competitor. When you receive a complaint or a bad review, the process to follow is to read it thoroughly and consider, where the review is coming from. I would suggest replying publicly with a thanks, an apology, and a promise to look into it promptly. And you may also want to request contact information to move the complaint to a private channel. You then move into a private channel to get a grips of the problem, be polite and professional, and if you did need time to investigate, say so and give them a time frame for getting back to them. At that point, once you've investigated, you can decide which remedy, if any, is appropriate. And if you did reject the complaint, set out your reasons clearly. So it is important to address every review that comes through.
Thanks, Tayler. All right. Are there any other? You got another question?
I've got another question here, so pre-submitted ones. So this question is, how can businesses protect themselves legally when working with influencers? So as we've covered in this webinar, being aware of the legal obligations which apply to your business products and services is an essential first step. You can then prepare a contract for the influencer to sign, which acknowledges these obligations and ensures that the influencer can and will comply with them. You should also always include the right for you to approve the content before it's shared, particularly if you're in those regulated spaces where you need to ensure compliance. And you should also request the right for you to request revisions to the content if there is anything that needs to be changed. You should also include within that contract the requirement that the advertisements will be disclosed, such as through hashtags and disclaimers.
Thank you, Tayler. We've got a question here that was also pre-submitted about somebody sharing someone else's marketing materials. So if someone takes your website or your marketing materials and shares them, this is sort of veering more into IP or intellectual property ownership rights. So in that instance, it would, I think, very much depend on the particular circumstances and what was happening. Obviously, people can't share your brand or use your brand in a way that is, I guess, misleading or would breach your intellectual property rights unless you've said that they can use it in that way. If it was sharing your website content for the purposes of showing friends, saying, hey, this website's great, come and have a look at this, or isn't this a cool logo, then that's a wee bit of a different story. But if they are using your branding or content to create the impression that they are somehow associated with you or that it's theirs, then that is obviously an issue and an infringement of your intellectual property rights, which we can help you do something about. Okay, great. Are there any other questions before we jump off? Awesome. Well, thank you everybody for coming. Sorry if we haven't answered more questions that there were pre-submitted, and please submit your details in the survey at the end for assistance with questions we didn't answer To learn more about how our membership can help you, please have a free consultation with our team. And while this is a free webinar, we do value your feedback. So please complete the 30-second survey at the end. Thank you very much for joining us.